Hello, good evening. Let us start the lesson. Today we would like to discuss regarding to the administration and the appointment and the powers of officers and administration of officers under state CGST, state GST and CGST or UT GST. And also we will discuss regarding to the GST audit by tax authorities. And the next, we may continue with appeal to the appellate authority, the application to appellate tribunal, etc., etc. So let us discuss about the administration officers who are being appointed under the GST Act. First of all, here uh, it is a earlier it was comes under the commercial tax office under the state level, the VAT, etc., people will exercise whatever may be the rules and regulations which are being stated by the central government and the state government. Now, we have, under the central government, we have the Central Board of Excise and Customs. Usually, they'll take care of all indirect taxes into the account. Earlier, it was only the customs and excise will be taken care of. Now, the GST comes under their purview. And the local level, that is the state level GST or the state level VAT, will be undertaken by the commercial tax office at the state level. So whatever may be the officers supposed to be appointed under this commercial tax office, they are supposed to write an examination under the state level Public Service Commission. Through that, they will be appointed the officers. And in case under the central government, that means the people who are supposed to appoint under the central government under excise department or the customs department or under related to the indirect taxes, they are supposed to qualify UPSC examination. So the people who have qualified under UPSC examinations may be appointed under the central government related taxes department. Now, the classes of officers, if you take into the account, first of all, we need to discuss under the CGST, that is Central Goods Service Tax, the Principal Chief Commissioner of CGST or the Principal Directors of General of CGST, Chief Commissioner of CGST, Director of General of CGST, he may be called whatever the name, the Principal Commissioners of CGST, Principal Additional Directors General of CGST, Commissioner of CGST, Additional Directors General of CGST, First Appellate Authority, Additional Commissioners of CGST or Additional Directorates of CGST, Joint Commissioner of CGST or a Joint Directors of CGST, Deputy Commissioners of CGST or Deputy Directors of CGST, Assistant Commissioner of CGST or Assistant Directors of CGST. So all these are the officers who have been appointed under the Central GST Act. Now at state level also, the state level, the goods and service taxes, the officers who have been appointed are Commissioner of SGST, Special Commissioner of SGST, Additional Commissioner of SGST, Joint Commissioner, Deputy Commissioner, Assistant Commissioner, and all other officers who are required to be appointed will be appointed under this. Now, the commissioner will have a jurisdiction over the whole state, and all other officers shall have a jurisdiction over the whole state. Such areas of the commissioner may be notified under the Act. Now, coming to the appointment, the board may appoint such persons as they think fit to be the officers under the CGST. As I told you, they will not take any prejudice into the account. The board may authorize to be appointed either a principal chief commissioner or a chief commissioner or a principal commissioner, a commissioner of central CGST, or an additional or a joint or a deputy or an assistant commissioner, whoever may be the officer whom they think fit, they will be appointed not below the rank of assistant commissioner of CGST. Now, coming to the powers of officers are: the board may impose an officer of the CGST, may exercise his powers or discharge the duties conferred which are imposed according to the Act. They also exercise the powers, discharge the duties, who is a subordinate to them, they are also will do the same thing. The next, they say that in case any powers supposed to be delegated to any of his officer who is subordinate to him, that should be decided by a board or a commissioner, subject to the conditions and limitations. They have to state what are the conditions and limitations. Based on that, only the board or a commissioner can exercise this power. And the first appellate authority, if you take it to the account, the powers which are the powers and the discharge of duties which are conferred under the CGST Act, they also will be mentioned under Section 79 of this Act. They take that into the account to implement. Now, let us discuss about the audit. Now, once we are maintaining the books of accounts under the GST, then automatically there is a need that we have to audit those books. So when we want to audit the books, then automatically who is eligible to audit and when it is to be audited. So this things we have to consider. So always they say GST audit and audit by tax authorities. We have, under the audit, we have two types. One is general audit and the another one is specific audit. So who will do the general audit and who will be doing under the specific audit? That we also need to discuss. Here, whenever we take the audit into the account, audit by tax authorities. Whenever an audit is to be conducted by tax authorities, first of all, the audit, what they have to inform, the taxable person shall be informed by way of a notice. They have to give well in advance, not less than 15 working days prior to conduct such audit, whatever the manner which is prescribed under the Act. The next, the audit should be carried out within a period of 3 months from the date of commencement of audit. Within 3 months, they have to complete their audit from the date of commencement of audit. They also need to state that the taxable person, in case the commissioner is not satisfied with whatever the data which has been provided, and the audit could not be able to complete it within 3 months from the date of commencement of audit, if the reasons are being recorded in writing, the period can be extended for another 3 months, but not exceeding 6 months. That means within 6 months, it has to be completed, not more than 6 months. So first of all, they will conduct the audit within first 3 months. And in any case, if it is delayed, then the commissioner is supposed to take the decision whether to continue or not. A further period can be extended or not. Even if he wants to extend also, after completion of 3 months, he'll see to it that whether another 3 months is required for them to conduct or not, but not more than that. That means complete audit will be taking place within a period of 6 months, not more than that. The next, what we have to take into the account is about the special audit. Now, special audit, that means scrutiny, inquiry, investigation, or any other proceedings which should be done before any officer who is not below the rank of a deputy commissioner or an assistant commissioner. So first of all, we need to see to it that we have to conduct an inquiry or a scrutiny or an investigation or any proceedings in front of an officer who is not below the rank of deputy commissioner or an assistant commissioner. Now, first of all, we have to, whatever the books of accounts need to be audited, it should be audited either by a chartered accountant or a cost accountant as may be notified by the commissioner in this behalf. So, before to audit, first the chartered accountant need to be, that means the officers will assign this particular job either to a chartered accountant or a cost accountant. See to it that the books will be examined, scrutinized, and investigate. See to it that it is being done properly. Now, either a chartered accountant or a cost accountant who is nominated to audit within a period of 90 days, and they have to submit a report of such audit which is duly signed and certified by them. And it is to be submitted to either a deputy commissioner or an assistant commissioner. The next, if a proper officer, whatever may be the application made by the taxable person or a chartered accountant or a cost accountant for any material, by providing sufficient reasons, can extend the period more than 90 days. So, they can extend for any of the reasons. The reasons should be satisfiable by a proper officer, then only it can be shifted to, that means extended. The period can be extended over and above 90 days. It is not in all cases. It is only a few cases where particularly it is required. There only it can be considered. And that too, a reason needs to be stated, and that reason should be acceptable by the proper officer. Then only the period can be extended. The next, what they say is, now the taxable person will be given an opportunity of being heard in respect of any material which is gathered on the basis of a special audit. Usually, like let us say, there could be some discrepancies or deficiencies or whatever may be the situation. In such cases, they can order the taxable person to give a sufficient reason. Principle of, usually natural justice, we call it as principle of natural justice is nothing but we will give a time limit for the person. That is, we will communicate the person stating that this is what a deficiency which is there, or this is what any difference of, or the, it can be an error, it can be a difference, it can be a deficiency, it can be something else where the explanation is called for. So in such cases, before taking an action, every time see to it that the person should be given an opportunity of being heard. That means he can able to communicate from his side what could be the reason why he has maintained in this manner. So that opportunity of being heard is the thing which is taken into the account. Once, whatever the reasons were stated, if it is satisfactory, or the expenses relating to the audit, incidental, examination, audit records, the remuneration, of the chartered accountant or a cost accountant, anything if you take into the account, all that's supposed to be settled as a final. The next, the results of detection of tax which is not paid or short paid, etc. Then input tax credit may be wrongfully availed. The proper officer can initiate any action relating to this. So this can be considered. Now, let us discuss to the next portion is about appellate, that is appeal and revision of tax. What do you mean by appeal? What do you mean by a revision? Have you heard these terms as appeal and a revision, which need to be taken under this act? Now, there could be some dispute between the taxable person and the authority, stating that maybe whatever maybe the assessment is being done according to the rule or the section. They will follow the rules, they will follow the sections. Basically, based on that, in case any dispute arise between the two parties, for one is the authority, the another one is the person, the supplier. He may be a supplier, he may be a taxable person, he may be an assessable person. So automatically what happens is whenever any such decisions which is aggrieved or order passed against him by the adjudicating authority, then both the parties, if they are not satisfied, either of them can make an appeal to the appellate authority. See, we may go to the court. Usually, people, when they have a dispute, when they have a problem to solve, usually what the common man will do is he has to go to the court. Court here is, we have a district-wise court we have. The next we'll have the High Court, the Supreme Court, like that. So first, what you have to do is, first you have to go to the tribunal or appellate authority, because in the commercial tax office, specifically they'll have a tribunal. So they'll appoint one authority as an appellate authority. So first, what you have to do is, if you are not satisfied with whatever the order issued by the authorities or whatever the assessment is being done, if the authorities, they themselves were not satisfied, first they will put forth this to the appellate authority. The step by step they have to go into the account. First, they will go to an appellate authority. They'll put forth all these information in front of them. If they have accepted and they think that whatever the judgment supposed to be given, that if without any prejudice or a bias, if they give the judgment and it is agreeable by both the parties, then automatically it is accepted. Even then, after stating by the appellate authority is not satisfactory, none of them were satisfied with that decision, then they will go to the appellate tribunal. Even the tribunal, whatever they said, if they are not acceptable, then they'll go to the next is High Court. Whatever the High Court says, even there also, if they are unable to satisfy, then they can go to the Supreme Court. Supreme Court is the final. So whatever the Supreme Court says, that is final, you cannot go beyond that. So that's the reason why any disputes arises between the two parties, then automatically the dispute need to be solved. So first they have to go to the appellate authority, appellate tribunal, and the stepwise they have to go. District Court, High Court, Supreme Court, like this they have to follow. So that's the reason why appeal. Here, that means appeal is nothing but we are put forth our issue in the front of the authorities. That's the reason why we call this as an appeal. Now, any person, so he can go to the appellate authority and put forth that whatever the dispute arises or the decision stated by the authorities is not acceptable. Then the adjudicating authority, like mostly the commissioner of GST, may be appointed as an adjudicating authority. Then in such a case, what they will do is they will examine the records, proceedings, which are being passed, any decisions or an order under this act. The purpose is to satisfy themselves whatever the decision was issued by the appellate authority is rightfully being given according to the section. Now, in any case, the authorized officer makes an application to the first appellate authority and see to it that application will dealt with the first appellate authority and see that whatever they have made the decisions, the adjudicating authority being done, all that they need to see to it. The next is the appeal. Whatever every appeal which is made under section shall be filed within 3 months from the date on which the decision is being sorted out. So within 3 months, it has to be sorted out. The next, what they say is, and whatever the appeal has been made, appeal should, that means the application along with the fee need to be sent to the appellate authority. So without a fee, an application cannot be acceptable. What is the amount of fee supposed to be payable? The amount of fee is mostly according to the section which is being stated. That means it is as prescribed by the authorities. The application along with the fee only accepted as an appeal. The next, we will take into the account, first of all, whenever you have a dispute relating to the amount, first you have to pay off that amount. Then you have to make an appeal, see to it that both the parties supposed to be agreed whatever may be stated by the appellate authority. In case whatever you have told them happens to be the right, then you are supposed to pay a lesser amount than whatever maybe is being stated for you. Then in such cases, even the authority also feels the same. Then they will refund that amount to you once this case is being solved. But without payment of any of the dispute amount, you cannot put forth any appeal as such. That's the reason why, first of all, you have to clear what all the dues you have relating to that particular issue. That first you have to clear off. You have a dispute because the amount which is calculated or assessed may not be done properly. Maybe it should be at a lower rate, but it is being charged at a higher rate. And you are not supposed to pay that amount. You have to pay a lesser to that amount. Or you might have paid already. That should be proved, and only the rest of the amount supposed to be the balance amount need to be payable. Whatever may be the situation, what you have to do it, that you have to clear all the dues. First, whatever the authority says, first you clear off. The next, put an appeal to the authorities and see to it that dispute will be solved. Once the authorities are also satisfied with your argument, then they only will issue an order stating that a wrongfully amount was calculated and it should be so and so, it should not be like this, and the rest of the amount should be credited back to the assessee. So that will be done afterwards. Now, if you have any fee which should be any interest supposed to be payable or a penalty you need to be imposed or something or the other dues are there regarding to such fee, such case, that all that you have to pay first, then only make an appeal. Now, and as well, the opportunity of being heard, that is a principle of natural justice will also apply in this case, in every case as such. First, they'll give a reason. They'll give a time to put forth your reason why you should not be charged or why there is a dispute. What are the reasons behind the dispute? All that should be given in writing, and they will record it in writing also. The next, they say 3 months time will be taken into the account, and they will search, examine, scrutinize everything, and whatever they think, if it is proper, conforming, modifying, whatever, they will pass such order, and that order should be acceptable by both the parties. If they have not accepted, then they have to go further. They may enhance any fee or a penalty or a fine or in lieu of confiscation or the goods. Uh, it can be anything will be taken care of. Now, the first appellate authority disposing of any appeal shall be in writing. They have to give it in writing. The orders always should be in writing so that the decisions, whatever may be stated, the decisions and the reasons for the decisions supposed to be stated in point wise. And in case if you are not satisfied, the same thing will put forth to the next step. That's the reason why it should be communicated in return. Now, in such case, if that is not being acceptable, then you can go to either a court or a tribunal. You can put forth the same to the court or a tribunal. Now, in the appellate authorities, they have a tribunal called National Appellate Tribunal. So, the central government has recommended the GST Council contribute a national goods and service tax appellate tribunal. So they have a national appellate tribunal. Here, the national appellate tribunal shall be headed by a national president. Appellate tribunal shall have one bench for each state, and which shall be called as a state GST tribunal. Every state GST tribunal was headed by the state president. Every state GST tribunal shall consist of members, judicially, technical, and technical relating to CGST and technical relating to SGST. These are the members will be exercising their powers and discharges their functions, which are conferred on appellate tribunal under this act. Now, the qualifications, eligibility, conditions, the manner of selections, appointments of a national president or a state president or the members shall be prescribed under the recommendations of the council. The national president, the state president shall exercise such powers and discharge such functions as may be recommended by the council. That is, we have a GST council. Now, in case ceasing to hold office, that means either the national president or state president or the members of the appellate tribunal shall not be entitled to appear, act, or plead before the appellate tribunal. The next, we will talk about appeals to the appellate tribunal. Now, here, in case the appellate tribunal, in its discretion, refuse to admit any such appeal where the tax or input tax credit which is involved, or difference in tax, or involvement of input tax credit, or the amount of fine or a fee or a penalty which may be determined by such order does not exceed 1 lakh rupees. So that means it is also a limitation which is given. Who are the people who can appeal to an appellate tribunal? That means whatever may be the amount, it should not exceed 1 lakh rupees. If it is less than that only, they have to go to appellate tribunal. If it exceeding 1 lakh, it may not be to the appellate tribunal. It is to some other thing we have to approach. The next, what they say is the board may, by order, constitute such committees. They'll they'll constitute such committees as may be necessary uh, for the purpose of filing appeals. Now, the committees which are designated, you need to see to it that under Section 79 is not legal or a proper. Direct any GST officer authorized on behalf of to apply to the appellate tribunal. They can determine such points arising and they will put forth as may be specified by the commissioner or the committee. Now, the next, they say the authorized officer makes an application to appellate tribunal. The application shall be dealt with. What are the reasons for which they are supposed to make an appeal? That they have to state here. Then every appeal under this section shall be filed within 3 months from the date of which the order is being sorted by the Commissioner of GST. Now, on receiving of the notice, appeal has been preferred under this section. They have to stated all this within 45 days of the receipt of that notice. A memorandum of cross objections verified in the prescribed manner. An order appealed against such memorandum shall be disposed of by the appellate tribunal within a specified period. Now, whenever a cross objection, a memorandum which is filing because of cross objection, the appellate tribunal may admit an appeal or permit the filing of the same. Now, whenever the appellate tribunal should be make an appeal in the prescribed format, in the prescribed form, with prescribed fee. So, without the fee, the appeal cannot be acceptable. That also need to be taken. As I told you, all the dues, everything need to be clear of. Taking all that into the account, they are supposed to be considered. The next, we have to talk about order of appellate tribunal. Now, coming to the order of appellate tribunal. Now, appellate tribunal may, after giving the parties to appeal, an opportunity of being heard is also being exercised. They will pass the orders as they think fit, confirming, modifying the decisions or the order appealed, may refer the case back to the first appellate authority or to the original adjudicating authority. As such, the directions which they think fit for a fresh adjudicating or a decision, for which the evidences are supposed to be stated. Whatever may be necessary, all that need to be stated and the evidences also need to be attached. And the reasons will be recorded in writing. The appellate tribunal will give a sufficient cause to be shown at the stage of hearing the appeal, grant the time from time to time, and the parties or any of them adjourn the hearing of the appeal for reasons to be recorded in writing. Now, the appellate tribunal may amend any order. See to it that what they think is right, its own accord, and brought to the notice by the Commissioner of GST or other party to the appeal within a period of 3 months from the date of the order. Now, the next they say whether enhancing an assessment or reducing a refund or an input tax credit or otherwise increasing the liability of other party, unless the appellate tribunal has given a notice to him of his intention that he can allow a reasonable opportunity of being heard. I told you that principles of natural justice will be applied. Without that, they cannot take any decisions as such, whether to increase or enhance the assessment or a refund, reducing a refund or an input tax credit, whatever may be the situation. So all this need to be considered under the appeal. Now coming to the appeal and a revision, we need to talk about the revisional powers of a commissioner. So what are the revisional powers of a commissioner? Now, under section 93 and the rules made under the act, the commissioner may on his own motion or upon information received by him or call for the examine the records of any proceedings under the act. He considers that any decisions or an order passed by the act by any officer subordinate to him who has given the decision prejudicially to the interest of the revenue, he may, if necessary, stay the operation of such decisions or an order as he deems fit, after giving the person a concerned an opportunity of being heard and further making an inquiry. He can pass such order as he thinks just and proper, including enhancing or modifying or annulling the said decisions. First of all, commissioner shall not exercise these powers more than 3 years, which have been expired after passing of the decision. That is one. Second thing, the order has been subject to an appeal under section 79 and 82 and section 87 and 88. Under these sections, the commissioners will not have a power to exercise. Whereas other than this, even if it is a longer period, that is more than 3 years, if it has been expired, even he doesn't have a power to exercise to revise the order. So that's the reason why what is to be done by a commissioner, what not to be done by a commissioner, that need to be stated under the act. The next, what they say is, whatever may be the decision or an order passed by the act, by an officer subordinate to the commissioner involves an issue on which the appellate tribunal or the high court has given its decision, which is prejudicial to the interest of revenue, then in such proceedings, an appeal to the High Court or a Supreme Court against such decisions can be taken care of. So they can go even to the High Court or a Supreme Court. Depends upon the decisions which has been taken into the account. The next, what they say is, we have the next is procedure of appellate tribunal. The powers and functions of appellate tribunal, when we exercise and discharge the benches constituted by national president or a state president from among the members thereof, first thing is we need to have a bench shall consist of one member judicially, one member technical under CGST and one member technical under SGST. So here we'll have a national president, a state president, or any other member of appellate tribunal authorized in this behalf for the national president or a state president. may sitting singly dispose of any case which has been allotted to the bench of which he is a member. In case a dispute case, the tax or input tax credit involved or a difference in tax or the amount of fine or a fee or a penalty involved not exceeding 10 lakh rupees. So here this procedure is applicable to an appellate tribunal where it is does not exceeding 10 lakhs. Now, if the members of a bench differ in the opinion, mostly it happens. See, whenever any decisions are being taken into the account and it differs, then automatically the how many members are there? The different the like let us say three members have three different opinions. They differ in that opinions in such cases. The point should be noted on which they are differing. They will take the opinion of the majority, and if the majority of them are divided equally among the members, then they will refer this to the national president or the state president, who shall be either hear the same points. That means that bench they will refer, see to it that they will able to give a communication or a decision. Even they also take the opinion of the majority of these members, and accordingly they will decide what should be the decision to be stated. Now, the next also they say that the powers and the duties which they are supposed to discharge should be stated according to the act relating to that bench who are hold to sit in that bench. The next, they say that the appellate tribunal, for the purpose of discharging its functions, discovery and inspection, enforcing the attendance of any person, examining him on oath, compelling the production of books of accounts and other documents, issuing commission, all this they have to take into the consideration for the purpose of discharging its functions. Okay. The next they say, any proceedings before appellate tribunal shall be deemed to be a judicial proceedings within the meaning of section 193 and 228. The next coming to the interest on delayed refund of pre-deposit. Now, any amount which is deposited by the appellant is a person who is making an appeal, is called as appellant. He might be deposited some amount as required to be refunded to any consequent order issued by the first appellate authority or an appellate tribunal. Then, as the case may be, the section 39 specified that any interest or any amount which is payable in respect of such refund from the date of payment of that amount should be returned. Next, appearance by authorized representative. Now, in any case, the applicant cannot appear in front of these appellate tribunals or the appellate authority. He can authorize some representative, so he is entitled or required to appear before GST officer appointed under this act. See to it that he cannot able to appear on so and so date. In such cases, he can have an authorized representative who is attending such issues on his behalf. So, first thing is, personally, he has to examine, take the oath, affirmation, subject to the provisions, appear by an authorized representative. So who can be called as authorized representative? Means a person authorized by the person on his behalf. Now he can be a relative, he can be a regular employee, or he can be an advocate who is entitled to practice in any court in India and who has not been debarred from practicing before any court. So they are stating even the who can be called as an authorized representative. Now, even he can be a chartered accountant or a cost accountant or a company secretary who holds a valid certificate of practice. So he also needs to have a valid certificate. The next, any other person who can acquire such qualifications as central government or the state government on recommendations of the council prescribed for the purpose. The next, they say any and no person who was serving in the indirect tax departments of the government of India or any state government as retired or resigned from such service may have served for not less than 2 years as a gazetted officer in that department shall be entitled to appear as an authorized representative. So already he has worked earlier under the state government or the central government. So he is not eligible to be appointed as the authorized representative. So that's the reason why they have been given the GST or in any proceedings before GST officer for a period of 1 year from the date of his retirement or resignation, as the case may be. No person who have been dismissed or removed from the government services, who is convicted of an offence connected with any proceedings under this act, who has become an insolvent, shall not be qualified to be a person as authorized representative. So that's the reason why this needs to be taken care of. And for such time, the commissioner of GST or a competent authority under the Act may by order determine in any case of a person referred taking the convicted offense that also we should not be considered. Then insolvency continues in case of a person that also will not be considered. Or if any person is found guilty of misconduct by prescribed authority in connection with any proceedings, even he also disqualified to be act as authorized representative. The next here, the other conditions, if you take into the account any order or a directions or any other conditions. So first, no such order or a direction shall be made in respect of any person unless the principle of natural justice be applied. That means a reasonable opportunity of being heard should be considered. The second, they say that whatever may be the order or a direction may be issued within 1 month from the competent authority to cancel such order or a direction. The next, they say that until the expiration of 1 month from the making thereof. So whatever the order was issued, expiration of 1 month. That means within 1 month they cannot be considered. Next, we have to talk about appeal to the High Court. So all these has been done, then still we have not satisfied, we have to proceed to the High Court. So when we will proceed to the High Court, then we have to make an appeal. We have to file an appeal to the High Court. Now, when we are making an appeal to High Court, first of all, we have to see to it that no appeal shall lie to the High Court against any order passed by the appellate tribunal. That means, first of all, it should be a clear-cut decision was given and you are not satisfied, then go to High Court. It's fine. But still here it is pending. Because there is a pending, you cannot go to the High Court. Till it is not cleared here, you cannot go to the High Court. This is what has been stated. The next, filed within 180 days from the date on which the order appeal against is received by the commissioner. This is one more condition which is to be taken care of. The next, they say the memorandum of appeal precisely stating the substantial questions of law involved. So whatever the questions which are raised need to be situated that it is solved or not. If it is not solved, then again it cannot go to the High Court. So they are giving you the conditions. What are the appeals which can be appeared in front of High Court? So if you have all such things which the High Court may not admit such appeal. So 180 days they'll take. See, High Court may admit an appeal after the expiry of period of 180 days, which are referred in the section. That means 180 days time will be given, whatever the appellate tribunal, appellate authority stated. So once they have stated, immediately you cannot go to the High Court. You have to wait for 180 days. After 180 days only, you can go to the High Court to make an appeal. Now, High Court, if they have satisfied with substantial question of law involved, then they will formulate that question. If they have not satisfied, they will formulate some other questions along with those questions. Now, High Court shall decide what should be deliver such judgment. High Court may determine any issue has not been determined by the appellate tribunal, may wrongly determined by the appellate tribunal, whatever may be the reason of decision of such question of law, herein is referred, that can be taken care of. Now, they also state that majority of the judges, whatever the point of law, they differ. They shall be referred or heard upon the point only, and one or more other judges of High Court bench, they'll refer it and see to it the opinion of the majority of the judges who have heard the case, including those who are the first heard of it. The next, they state, High Court delivers a judgment in an appeal filed before it. Now coming to the appeal to the Supreme Court. So whatever may be the High Court decision, if it is not satisfactory, then it goes to the Supreme Court. You can appeal, shall lie with the Supreme Court for any judgment or any order which is passed by the High Court, on which its own motion or on an oral application made by or on behalf of a party agreed immediately after passing the judgment. Now, one more you have to take into the account is whatever may be lying in the Supreme Court, then no order can be passed by either an appellate authority or a tribunal. The Supreme Court, once it has been accepted, then no other party has a power to discuss relating to that issue. So hearing in the Supreme Court will take off the provisions of Code of Civil Procedures relating to the appeals to the Supreme Court. The cost of the appeal shall be at the discretion of the Supreme Court. The judgment of High Court, etc., can be varied or reversed in the appeal. Effect shall be given to the order of Supreme Court. The Supreme Court may give you the same judgment was whatever may be given in the High Court, or it may be a different judgment may be given, maybe a reverse judgment may be given, whatever is being given in case of the High Court. So all this need to be considered regarding to the appeals. Appeal not to be filed in certain cases, that also need to be considered. What are the certain cases? Here, on recommendations of the council from time to time, will issue the orders or the instructions or the directions fixing such monetary limits as they deem fit. They also mention what are the issues which can be applied, which cannot be applied. So appeal not to be filed in certain cases. They'll issue a notices stating that these are the cases where appeal cannot be made or appeal can be made. So if it has been stated, then accordingly you have to act. Then there could be some demand, there could be some misconduct, all that will be considered, or the qualification that also we have discussed. Uh, Taking all this into the considerations, appeal, you appeal or a revision, the powers of appellate authority, tribunal, high court, supreme court, all that we have discussed. Now, any doubts, any doubts you have?
Ma'am, tomorrow is last class now, ma'am.
Yes.
Okay. Can you share important questions also?
Yeah, definitely. After completion of my lesson, automatically I'll give you the important questions. And
Okay.
are you following?
Yes,
Do you
ma'am.
have any doubts?
No, ma'am.
Fine. Actually, I lost one class because of the rain.
Yes, ma'am. Second day, na?
Second day, I could
Yes.
not able to take. I also put forth the same thing with the authorities. I don't know whether I'll get that class or not. Okay,
Okay.
even if they give me the time or not, that is fine. I'll complete the whole portion and I'll see to it that I can give you the important questions as such.
Okay, ma'am.
So thank you. I'll be leaving now. Tomorrow we'll meet again.
Okay, ma'am.